Assalamu alaikum and welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia. This is the second part to the show. Just before we had the break, we had a caller who was calling about an extension application or potentially an indefinite leave to remain application. And what the caller was explaining was that initially the wife came to the United Kingdom on the 15th of August 2012. She'd had the visa extended and was looking to see whether she could qualify for indefinite leave to remain in the United Kingdom. And what I asked the caller to do is to look at two things. First of all, the initial grant of the visa to see how long that was for, and also to look at when the extension was granted to see how long the extension was for. Now, the reason for that is I was trying to work out whether this is a case which comes under the old rules for spouse applications or whether it comes under the new rules for spouse applications. Now, there's a fundamental difference between those two rules, both in terms of the length of time it takes for somebody to apply for indefinite leave to remain, and also the requirements that need to be fulfilled, most importantly in terms of the financial requirement, whether that needs to be met or not. Now, normally it's easy to work out whether the application comes within the old or the new rules. It's not necessarily when somebody comes to the United Kingdom that you need to look at, or even when the visa was granted that you need to look at. What you need to look at is when the application for the visa was made initially, which resulted in the visa being granted. Now, if the application was made before, I think, June or July 2012, then it would come under the old rules. Now, the other way you can work out whether it's an old case or a new case is to look at how long the visa was granted for. If the visa is granted for 2 years and 3 months, it will be under the old rules. If it's granted for 2.5 years or more, it will be under the new rules. And lastly, obviously the person making the application would normally know whether they met the requirements at the time of the application or not. Let's take our call and return to this after that. Hello, Assalamu alaikum.
Hello, Assalamu alaikum.
जी वालेकुम सलाम जी, thank you for calling जी.
सर मैंने पूछना था, मेरे पास लीव टू रिमेन है
जी, ठीक है, ओके
सर। मैंने बच्चों को पाकिस्तान से बुलाना था
जी, ठीक है, ओके ओके। आपकी जो लीव टू रिमेन है वो किस बेसिस पे है लीव टू रिमेन?
ये मुझे सालम के में मिली थी 2014 में,
राइट,
इलेक्ट्री स्कीम में।
ओके, वो लेगेसी में मिली थी आपको
जी
2014 में। आपके वीज़ा कार्ड पे कोई लिखा है कि आपको रेफ्यूजी स्टेटस दिया है, ऐसा कुछ लिखा है?
नो, लीव टू रिमेन ये लिखा है।
हाँ, रेफ्यूजी नहीं है ना, रेफ्यूजी स्टेटस?
नो 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 नो, रेफ्यूजी नहीं है।
ऑलराइट। और उसने जो आपको वीज़ा दिया है लेगेसी में, वो तो ये है ना जो 10 साल के बाद इंडेफिनिट होगा, वो है ना वीज़ा आपके पास?
जी
जी, 10 साल वाली। असल में इसमें प्रॉब्लम क्या है कि बिकॉज आपके पास इंडेफिनिट लीव नहीं है अभी, और आपके पास रेफ्यूजी स्टेटस भी नहीं है और ह्यूमैनिटेरियन प्रोटेक्शन भी नहीं है, तो इसलिए आप बच्चे को स्पॉन्सर नहीं कर सकते। आप अभी वाइफ को भी स्पॉन्सर नहीं कर सकते, बच्चे को भी नहीं कर सकते स्पॉन्सर इन द यूके, जब तक आपका इंडेफिनिट यहाँ नहीं हो जाए। सो आपके जो स्टेटस है ना, उसको देखना पड़ता है कि वो जो स्टेटस आपको मिला है ना, अगर इंडेफिनिट है तो ठीक है, अगर रेफ्यूजी ह्यूमैनिटेरियन टाइप प्रोटेक्शन है तो ठीक है। वैसे वो डिस्क्रेशनरी लीव जो देते हैं, डिस्क्रेशनरी लीव, तो वो लोग जब तक उसका इंडेफिनिट न हो जाए वो स्पॉन्सर नहीं कर सकते। तो उसने आपको इंडेफिनिट नहीं दिया था 2014 में?
नो, इन्होंने लीव टू रिमेन 2.5 साल का मेरे को दिया।
प्रॉब्लम ये है ना, वो 2.5 इयर्स का वीज़ा देते हैं, और वो जो 2.5 इयर्स का जो वीज़ा है ना, वो नॉर्मली 10 इयर्स के बाद वो इंडेफिनिट उसका मिलता है, 10 इयर्स के बाद।
जी,
तो इसमें प्रॉब्लम ये है, एक तो किसी को स्पॉन्सर नहीं कर सकते यूके में, दूसरा प्रॉब्लम ये है कि उस पर बेनिफिट्स भी नॉर्मली नहीं मिल सकती। आपको बेनिफिट्स मिल सकती है या नहीं इसमें?
नहीं, बेनिफिट वाला हुआ है मेरे को।
ऑलराइट, ठीक है ठीक है। सो
मैं काम भी फुल टाइम कर रहा हूँ।
काम भी फुल टाइम कर सकते हैं, मगर प्रॉब्लम यह है कि जो ऑफिशियल रूट जो होता है, जो बच्चे को स्पॉन्सर नहीं करेंगे। आपके पास यूके में वाइफ है यूके में?
जी जी, यूके में इधर शादी की थी ना, वो उनके पास भी सेम है।
ओके, ऑलराइट, उसके पास भी सेम है। चलो ये
जी, मेरे बिहाफ से मिला था।
राइट। मुझको ये हुआ कि शायद कोई उसके पास डिफरेंट टाइप की कोई अगर वीज़ा है तो वो भी यूज़ कर सकते हैं।
जी
मगर आपने जैसे डिस्क्राइब किया ना, आप अभी के लिए थोड़े से स्टक है। जब आपका इंडेफिनिट हो जाएगा तब आप स्पॉन्सर कर सकेंगे। मगर प्रॉब्लम ये है कि जब आपका इंडेफिनिट होगा, अगर बच्चे की उम्र अगर 18 से ज़्यादा हो गई तो वो भी प्रॉब्लम होगा, बिकॉज वो
यही प्रॉब्लम है ना। अभी बेटा तो 15 का, तो जो डॉटर है वो 16 की है, इसलिए वो 10 ईयर तो बहुत लंबा टाइम हो जाएगा ना।
प्रॉब्लम ये है कि अगर आपके चिल्ड्रन कोई और तरीके से अगर यूके में आ जाए लीगली, तो अगर वो आ जाए स्टूडेंट पे विजिट पे, तो देन यू कैन सी वेदर इट इज़ पॉसिबल लेटर ऑन कि कोई एप्लीकेशन कर सकते हैं या नहीं। मगर आपने जैसे आपका सर्कमस्टांसेस डिस्क्राइब किया, अभी के लिए थोड़ा सा डिफ़िकल्टी में है आप बच्चे के लिए।
ओके
जी भैया, थैंक यू, आपने कॉल किया, थैंक यू वेरी मच,
थैंक
यू वेरी मच, इंडीड। विल टेक आवर नेक्स्ट कॉल, ट्राई अगेन। हेलो, अस्सलाम वालेकुम। हेलो जी, हेलो, यू आर लाइव ऑन है जी। जी, व्हाट्स योर क्वेश्चन प्लीज?
हमने बस ये पूछना था कि ब्रिटिश पासपोर्ट अप्लाई करने के लिए जैसे क्या क्या चीज़ लगानी पड़ती है साथ में?
जी, वैसे ब्रिटिश पासपोर्ट का एप्लीकेशन नॉर्मली स्ट्रेट फॉरवर्ड होता है। फर्स्ट ऑफ ऑल ये देखना पड़ता है कि जो अप्लाई करेगा ब्रिटिश के लिए, तो उसका जो पार्टनर है, हस्बैंड और वाइफ, वो ब्रिटिश है या वो भी नॉन ब्रिटिश है?
नहीं, हस्बैंड के पास अभी लीव टू रिमेन नहीं है।
जी ठीक है, ऑलराइट, ठीक है। तो वो सिचुएशन में फर्स्ट ऑफ ऑल तो ये यू हैव टू मेक श्योर कि यहाँ 5 इयर्स यूके में लीगल हो गए, 5 इयर्स, ओके। और आपको इनडेफिनेट लीव भी चाहिए, और एप्लीकेशन में डॉक्यूमेंट्स।
हाँ जी, नहीं सॉरी, मेरे पास इंडेफिनिट लीव टू रिमेन है, सब
जी
कुछ है।
ओके, ठीक है,
12-13 साल हो गया।
चलो फंटास्टिक। तो सिर्फ आपको
जैसे मुझे
जी
सिर्फ यही पता करना था
जी, तो आपको पासपोर्ट सबमिट करनी है लास्ट 5 इयर्स की पासपोर्ट। I think that we'll take a next call. I'll come back to this question. Sorry, it's been disconnected, but I'll come back to this in a second. I'll take this caller who's now on the line. Hello, assalamu alaikum.
Walaikum assalam. I just spoke to you. I've had a look at the date
Right,
for
fantastic.
my wife's visa.
Yep, fantastic. Yep. Okay.
So the visa was issued. The initial visa was issued on the 11th of July.
Yep.
2012.
Yep, understand.
Until the 22nd of June 2014. So the initial period given was for 2 years.
Okay.
Then I did an extension. Then I did a further extension, which was from the 22nd of June to 2014.
Yep.
To the 2nd of December 2016, which was about 2.5 years. Then I further got an extension.
Okay.
Which was from the 2nd of December 2016 to the 13th of June 2019, 2.5 years.
You see, you know what's happened? Initially, you know, the visa that was granted, initially the visa that was granted, to me, it looks like it was under the old rules, and you could have qualified for indefinite leave at that stage, because the visa was granted for 2 years and less than 2.5 years. And you know, when your wife initially got the visa, did you have to meet the 18,600 requirement?
I think so. I did. Yes.
I think it's probably, from my calculation, it's unlikely that you would have met it, because had you met it, then she would have been granted a 2.5-year visa. But from the dates you've given,
yes,
she's granted she's granted a 2-year visa initially.
Correct.
Anybody who's granted a 2-year visa is definitely under the old rules. But I think then what's happened is, because you haven't applied for indefinite leave, and when you've applied for the extension, you probably not complied with the strict requirements for the extension. That's why, to me, it looks like she's now been placed on the 10-year route potentially to settlement. Do you have
10 years?
I think this is the problem. Because the visas that you have subsequently been given, the visas have been for 2.5 years.
Yeah, correct.
She shouldn't have been given a 2.5-year visa. If somebody is under the old rules, and even if you don't apply for indefinite leave, you apply for an extension properly, because let's say, for
Correct.
example, she hasn't passed her English test, and you just want an extension under the old rules. The extension is for 2 years. You remain under the old system until you apply for indefinite leave, and you can apply at any stage under the old system. Now, the way you've described it, what's happened is you start off under the old rules. You get the 2-year
Correct.
visa. Then, for some reason, you've ended up with 2.5-year visas. The
Correct.
fact that you've been given 2.5-year visa, to me, suggests that you've now come out of the old rules and now entered the new rules. And it's possible, and I can't tell without looking at the papers, that you've entered into the 10-year route. But it won't be a problem. It's not a significant problem, because she has been legally in the UK since 2012.
Correct.
So she would be able to qualify under long residence in 2022. But whether she qualifies now for indefinite leave, that will depend on what happened when you made the first extension application. I think she's come out of the old system into the new system. You would have got a letter when she was granted the first 2.5 years in the UK. You would have got a letter, and that letter will say what the route is that she is now.
No, but I think on the letter it says clearly, I'll have to go back to the letter to have a read through again.
Yeah, you sure?
But it says it clearly that she qualifies within 5 years.
Then it's a bit odd. Why would she be placed under the 5-year route to settlement? She should have just been given a 2-year extension, and you could qualify at any stage for settlement.
Because I think the initial rule was for 2 years, and then they extended it to 5 years.
Yeah, but that doesn't apply to somebody who is in the old system. If you come within the old system, the old rules continue to apply to you. You don't go into the new 5-year route or the new 10-year route. You continue under the old system. But look, if you're sure that there was a letter which said that you are now being placed under the 5-year route to settlement, which seems to me to be like somebody's made a mistake somewhere. Anyway, let's say there is a letter to that effect, then fantastic. She should make the application for indefinite leave after 5 years. And at that stage, you need to obviously meet the income requirement of 18,600. She needs to pass the English test, the Life in the UK test, the B1 in English. But the way you've described it, just make sure you do get advice from a specialist immigration solicitor first. It's a bit muddled. It shouldn't be the way you've described it. Okay, I'm not saying you've made a mistake. It could be the caseworkers made a mistake. It's a bit muddled. So I wouldn't go and spend, the £2,300 for settlement straight away. I would try and get proper advice. And what you need to show your lawyer is, like you've worked out today, initial visa, the extension, the letters that she got for the extension. I think this just, something doesn't seem quite right to me the way you've described it. Now, show it to a proper immigration lawyer. If you want me to look at it, you can leave your number with the control room. I'll try and call you back. And even if you WhatsApp to me the relevant visa stamps and the letters, I'll be able to look at it further. It's just something doesn't seem right to me in the way you've described it. I'm not saying you're wrong. It could well be that the caseworkers moved you to the new system when they shouldn't have. But let's say it is what it is. All I'm saying is just make sure before you apply for settlement that you do get somebody to look at it properly in terms of the history as to where you've ended up. Okay. Right. Thank you very much. Thank you very much for your call. Thank you. We'll take our next call. Hello, assalamu alaikum. Ji, walaikum salam. Ji, thank you for calling. Ji, what's your question?
Hello.
Hello, hi. Ji, thank you for calling. What's your question?
Shall I go now?
Yep, you're live on air, so you can ask whatever you want to ask.
So I just wanted to ask, my father, he bought some property while he was working in the Gulf.
Okay.
A property in Pakistan. So when he came here, does he need to show that to the government over here?
No, he doesn't. He doesn't. The issue really arises not when you hold an asset abroad. The issue normally arises when you have an income from the assets. If you have an income from land, if you have an income from rental property, and you are living in the United Kingdom, it could be that there could be tax implications on the income that you receive from property, even if it is property which is abroad. There are tax implications which arise from income that you receive abroad.
But like if it's just land, does he need to?
No, not land. No.
It has to be like proper residential.
No, not land. Income is the only issue. Obviously, then there could be another issue if you're claiming benefits. If you're claiming certain benefits, they ask you whether you own assets or not. Then potentially it's an asset which has to be declared and which may have an impact. But that's normally the two areas where you have an income, or you're claiming benefits and you're required to disclose your assets. And if you have an income or you're claiming benefits and you disclose it, it could, I'm not saying it will, it could have an impact on
he's retired and he doesn't claim any benefits.
Then there's no problem. Then I can't see a problem at all.
What about like if he were to sell property or land in Pakistan?
If you sell, okay, right. Yeah. I understand what you're saying. If you sell property or land in Pakistan and again you make a profit, there may be tax implications.
So who's deciding what the profit is? What it was valued when you bought it?
Yeah. So if you look at, let's say you bought property valued at £100,000, and when you come to sell it, it's now worth £500,000. There's a potential profit, and on that profit, there's an issue about taxation. The reason the taxation issue arises is that because your dad is living in the UK, and tax legislation applicable to him would be that applicable in the country of your residence. And the way taxation works is that there are treaties with other governments, so that if on that profit he is taxed abroad, then it may well be that he doesn't have to pay tax here. So there's issues. Initially, the starting point is potentially profits are taxable, but there are double taxation treaties with other countries, which means that if tax has been paid already in that country, it may well be that tax is then not payable in the United Kingdom.
Okay.
So there's issues about your residence normally determines where tax is payable, not where the profit is made. Your residence determines where tax is payable, but there are double taxation treaties as well, which may protect you in any event. So ultimately, it may be that there is no tax payable even on a profit, because you paid the relevant tax abroad. The best people to talk to you in relation to this would be, first of all, accountants, and secondly, if you go onto the HMRC website, there is a specific section for people who hold property, etc. abroad. So if you go onto the HMRC website, there is actually a contact number that you can call, and they are specialists in dealing with profits or income on assets which are abroad. So they could give you some guidance as well. But accountants or the HMRC would be best people to talk to, just to get a general idea about what the position is. But as I've said, the general position is, if you live in the UK, wherever you make the profits, potentially there's a tax problem, but double taxation treaties could protect you in any event, which means that you don't have to pay taxation again on profits which you've paid.
So this tax, it applies if he were to move the money here, but if the money stays there.
No, it's not the movement of money which triggers the taxation. It's a sale which would trigger the. It's the profit that's made when it's materialized, when the profit is realized. At that stage, for example, let's say in Pakistan there's land and it's sold, and a profit has been made. There could be tax payable to the Pakistan government or whichever country it is. We might have a culture of not paying, but really tax is payable. Now, there are different rules. Agricultural land may not be subject to tax. Other commercial land may be subject to tax. But you've got to look at what the position is in that country, and you also need to look at whether, if tax has been paid there, you would normally be protected from paying taxes here. But you do need to look at to get advice from an accountant really on this, as opposed to a lawyer, an
But
accountant.
then paying tax in Pakistan would be way cheaper than paying the tax profit over here.
Sorry,
So,
say again. Sorry, say again.
like if we were paying, I mean, if he's paid or if he is paying tax on the profit from the land,
Yeah.
then it would be much cheaper to pay the tax in Pakistan. Then why would it apply here anyway?
Why would it apply? Because the law might make it applicable now.
You said that if you pay taxes one country, you don't have to pay it here.
There are double taxation treaties. It's not as easy as that, and I don't think you can generalize in the way that you're generalizing. There are double taxation treaties. That's why I don't think I can give you a comprehensive answer. I'm not an accountant. I'm not a tax lawyer. You need to speak to an accountant or HMRC about it. But in answer to your...
But either way, like if it's sold and the money is there, that needs to be it needs to be shown here.
Well, let's say you make a profit abroad, okay? If the rules are that it's potentially taxable, then the rules would be that when you do your tax returns, or you should do your tax returns, and then you should declare it.
Oh.
Whether you do that or not, it's a matter for you, but I can hardly tell you live on air that don't declare it. If the rules are that there's a potential profit, you need to declare it. That's what the rules are. But look, instead of us going around in circles, I think the best thing is that you speak to an accountant or HMRC and clarify it with them. Okay, brilliant. Thank you very much for your call. Thank you. Thank you. Right. Okay. So that's that. Just going back to one of the questions that I took earlier. I do apologise. I've been told there are a number of calls waiting. Let me take that. Let me take the next call. Hello, assalamu alaikum. Oh, I think they're tired of waiting and they've left us. Okay, it's not a problem. Let me go back to the question that I took earlier on the British passport application and what documents need to be submitted. Generally speaking, passport applications are the easiest applications to make, in the sense that the documents that need to be submitted are, generally speaking, quite straightforward. Main documents, if your partner is not British and you're making the application in your own right, like the lady was, you will need to submit your passports. And your passports need to cover the last 5 years in the United Kingdom, because they want to look at your residence in the United Kingdom over the last 5 years. So your passport covering the last 5 years should be submitted as a starting point. Secondly, confirmation that you've got indefinite leave. That will normally be on your biometric residence permit. It'll say indefinite leave. Or if it's an old application that you made and you got indefinite a while ago, it may well be in your passport. So your passport and your confirmation of your indefinite leave to remain. That's the second document. Third document is one passport size photograph which is stuck on or stapled to the nationality application form. Then you need to submit, fourthly, your Life in the UK test certificate and your B1 English certificate. If you, I think, have recently got indefinite leave in the last couple of years, there's a box that you tick and you won't need to submit evidence of that. But I think if it's an old application, I think off the top of my head, prior to 2013 or 14, if you got indefinite leave, you will need to submit the Life in the UK test and the B1 certificate. The form, as you go through it, the form will tell you when you don't need to submit it, when you automatically qualify. So passport, biometric residence permit, one photograph, Life in the UK test certificate and the B1 English certificate. That's in a normal general case. Obviously there are exceptions, but that depends on your own circumstances. For example, if you're over the age of 65, you don't need to submit the Life in the UK test or the B1 certificate. So there are exceptions to the rules, but generally speaking, passport, biometric card, one passport size photograph, Life in the UK test and a B1 certificate in English are the documents that you need to submit. The form that you need to complete is available on the Home Office website. I think it's AN1, I'm not sure. Check on the website and it's a standard basic form that needs to be submitted. Just one point before we leave that topic. Once the form is completed, supporting documents are put together, 2 referees will need to countersign the form. So they will be saying that they know you for a number of years, I think it's the last 2 years, etc. And you are who you say you are, and then you can submit the application with a fee which is in the region of £1,200. You then wait 4 to 5 months, and hopefully, all being well, you should be able to qualify for citizenship, and that citizenship document will then mean that you can apply for a British passport. So that is a summary of what you need to submit, what you need to do when you want to make a citizenship application. Unfortunately, that does bring us to the end of the show. Inshallah, we'll be back next week on Monday at 6 o'clock, and we can look at these matters in greater detail then. Okay, till then, Assalamu alaikum.